The courtroom was stuffy, the kind of place where time moved slower than it should. Fluorescent lights buzzed overhead, casting a pale, tired glow on rows of wooden benches filled with people waiting for their cases to be called. Some tapped nervously on their phones. Others stared at the floor, arms crossed tight like they were holding themselves together. At the front, behind a tall bench that looked more like a throne than a piece of furniture, sat the judge, older, sharp-eyed, with a voice that carried like a gavel strike. He'd been on the bench for over 20 years. Seen it all, or so he thought. Traffic violations, small claims, petty thefts. He handled them like clockwork. Efficient. No nonsense. And if someone showed up looking like they didn't belong, he wasn't shy about letting them know. That's when she walked in. She was young, maybe 17 or 18, with dark skin, curly hair pulled back in a loose ponytail, and wearing a faded gray hoodie that looked like it had seen better days. Her sneakers were scuffed, her hands tucked deep in her pockets as she approached the defendant's table. No lawyer beside her, no parent. Just her, standing alone in front of the American flag and the seal of the state. The clerk called her case a simple traffic stop. Broken taillight. But something about the officer's report made it more complicated. Alleged suspicious behavior, refusal to answer questions, non-compliance, the kind of language that could turn a $50 fix into a courtroom appearance. The judge glanced at her file, then up at her, eyebrows raised slightly. "You're representing yourself?" he asked, voice flat. "Yes, Your Honor," she said, clear and steady. He let out a quiet sigh, the kind adults make when they think a kid is about to waste their time. "All right. State your name for the record." "Maya Johnson," she said. He nodded, already flipping through papers. "Miss Johnson, this is a court of law, not a classroom. Do you understand the charges against you?" "I do, Your Honor." "Good. Then let's keep this brief. The officer says you were evasive, refused to produce your license when asked, and argued with him over a broken light. That correct?" She took a breath. "With all due respect, Your Honor, that's not accurate. I did produce my license. I asked why I was being detained after the light issue was resolved. The officer said I matched a description, but didn't provide any details. I simply asked for clarification." The judge cut her off with a wave of his hand. "Hold on. You're telling me you, a teenager, started questioning a sworn officer during a lawful stop?" "I asked one question, sir," she said calmly. I didn't raise my voice. I didn't resist. I just wanted to understand why I was still being held. He leaned back in his chair, arms crossed. A small, dry chuckle escaped him. "Oh, I see. So you're playing lawyer now? Did you watch a few courtroom dramas and think you could argue your way out of this?" A few people in the gallery shifted uncomfortably. The bailiff glanced toward the judge, then back at the girl who hadn't flinched. "No, Your Honor," she said, voice still even. "I'm just stating what happened." The judge's tone sharpened. "Young lady, this isn't debate club. Do you even know what an objection is? Or are you just improvising as you go?" The words hung in the air like smoke. Some in the room looked down, embarrassed for her. Others watched with quiet curiosity. But she didn't look ashamed. She didn't look angry either. Just focused, like she'd been here before. Like she knew exactly where this was going and how to navigate it. "I understand courtroom procedure, Your Honor," she said simply. He raised an eyebrow, almost amused. "Do you now? Then by all means proceed. But I'll warn you, wasting the court's time won't earn you any favors." She nodded once. "Thank you, Your Honor. I'd like to call the arresting officer for cross-examination." The judge blinked, then let out a short laugh. "You want to cross-examine the officer? Yourself?" "Yes." He exchanged a look with the prosecutor, who shrugged slightly, clearly as surprised as anyone. "Fine," the judge said, waving a hand. "Officer Daniels, please take the stand." A tall man in uniform stepped forward, adjusted his belt, and was sworn in. He gave his testimony smoothly, the usual script, saw the broken taillight, initiated stop, noticed nervous behavior, asked for ID, felt threatened by her questions, decided to detain her further for officer safety. When it was her turn, she stood slowly. No notes, no folder, just her standing straight, hands resting lightly on the table. "Officer Daniels," she began, "you stated in your report that I refused to comply when you asked for my license. Is that correct?" "Yes," he said. "Yet your body cam footage, submitted as Exhibit A, shows me handing you my license within 10 seconds of your request." correct? He hesitated. I may have misspoken, but you were still uncooperative. Uncooperative how? She asked. At 2:14 into the video, I say, Officer, the light's fixed now.
Am I free to go?
Is asking that a crime? The officer shifted. It's the tone, ma'am. You sounded confrontational. Confrontational, she repeated. Or just clear? Because in the same clip you tell me, don't get smart with me before placing your hand on your taser. Was I under arrest at that point? I was ensuring my safety. And yet, she continued, Georgia Code Prior 48-23 states that equipment violations like a broken taillight are non-moving infractions that don't justify detention once the issue is acknowledged or resolved. Did you cite me for the light? No. Then why wasn't I allowed to leave? The officer glanced at the judge, who was now sitting very still, eyes narrowed. She didn't wait for an answer. Also, you mentioned I matched a description. What description? Of what crime? At what time? In what area? I don't recall the specifics. You don't recall, she said softly, but you detained me based on it. The courtroom was dead silent now. Even the clock on the wall seemed to pause. She turned slightly toward the bench. Your Honor, under State v. Ellison, 2018, a vague resemblance to an unspecified suspect does not constitute reasonable suspicion for prolonged detention. And under Terry v. Ohio, any stop must be justified by specific and articulable facts, not general unease. The judge stared at her. His mouth opened slightly, then closed. He looked down at his notes, then back up as if seeing her for the first time. Not as a kid in a hoodie, but as someone who knew the law better than half the attorneys who passed through his courtroom. He cleared his throat. Where did you learn all this? She met his gaze evenly. I study law, Your Honor. He scoffed, but it lacked its earlier confidence. Study law? You're barely old enough to drive. I'm a third-year law student at Emory, she said, and a licensed student practitioner under Georgia Supreme Court Rule 92. A murmur ran through the room. The prosecutor sat up straighter. The bailiff's eyes widened, the judge's face went pale. He looked at her file again, then at her, then back at the file, as if the words might rearrange themselves into something that made more sense. You're an attorney? He asked, voice lower now. I'm representing my younger brother, she explained. He was driving. I appeared pro se to handle the matter without adding legal fees to our family's burden. The judge sat back slowly, like the weight of his mistake had just settled on his shoulders. He didn't say anything for a long moment. The air felt thick, charged with something new. Respect, maybe, or regret. Finally, he spoke quieter than before. Proceed with your argument, Ms. Johnson. And just like that, the room changed. The girl in the hoodie wasn't just a defendant anymore. She was counsel. And everyone, especially the man on the bench, knew they'd misjudged her completely. The courtroom felt different now. The air had shifted, like a storm had passed through without thunder, leaving everything clearer, sharper. People sat up straighter. Even the prosecutor, who'd been scrolling through emails on his phone just minutes before, now had his full attention locked on the young woman at the defense table. She hadn't raised her voice. She hadn't made a scene. But something about the way she stood, calm, grounded, like she'd been preparing for this moment her whole life, made everyone lean in. The judge cleared his throat again, slower this time, almost careful. You may continue your cross-examination, Ms. Johnson. She nodded once, then turned back to the officer on the stand. Her voice stayed steady, but there was a new edge to it, not anger, but precision, like a scalpel finding the exact spot it needed to cut. Officer Daniel, she began, you mentioned earlier that you felt threatened during our interaction. Can you describe what specific actions I took that made you feel that way? The officer shifted in his seat. Like I said, your tone. The way you looked at me. You didn't follow instructions right away. Instructions to do what? She asked. To stay in the car. I was never told to stay in the car, she said gently. At 1:47 in the body cam footage, you say, step out of the vehicle. I complied immediately. No hesitation. No argument. That's not how I remember it. But the video exists, she said, and under Georgia law, body cam footage is considered official record. So if your memory contradicts the recording, which one should the court rely on? The prosecutor started to object. Your Honor, she's badgering the witness, but the judge held up a hand. Overruled. The question is relevant. The officer swallowed hard. Sweat glistened at his temple, though the room wasn't hot. She didn't press further. Instead, she walked slowly to the evidence table, picked up a printed still from the body cam, and held it up. This frame shows me standing 3 feet from your vehicle, hands visible, palms open. Is that correct? Yes. And at no point did I reach into my pockets, make sudden movements, or approach you aggressively? No. Then what exactly was the threat? He didn't answer right away. When he did, his voice was quieter. It's hard to explain. It's just a feeling you get sometimes. A feeling, she repeated. Not a fact. Not a violation. Just a feeling. She let that hang for a beat. Then she turned to the bench. Your Honor, in State v. Carter, the Georgia Court of Appeals ruled that an officer's gut feeling without articulable facts cannot justify extending a traffic stop beyond its original purpose. This stop lasted 23 minutes for a broken taillight, a non-moving violation that carries no jail time. During that time, I was questioned about my neighborhood, my school, and whether I usually drive nice cars. None of that relates to vehicle equipment. The judge's jaw tightened. He glanced at the prosecutor, who now looked like he wished he'd settled this before it reached the courtroom. Counsel, the judge said, addressing the prosecutor, do you have any legal basis for the extended detention? The prosecutor hesitated. Your Honor, officer safety is always a concern. But was there any behavior that actually threatened safety? The judge pressed. Or was this just suspicion based on appearance? The prosecutor didn't answer. He just shook his head slightly. Maya turned back to the officer. One last question, Officer Daniels. When you wrote in your report that I matched a description, did you file a bolo be on the lookout for anyone that night? No. Did you radio dispatch to confirm if any suspects were at large in the area? No. Then how could I have matched a description that didn't exist? The officer stared at his hands. I can't say, she nodded. No further questions, Your Honor. She walked back to her seat, not with triumph, but with quiet resolve. The kind of calm that comes not from winning, but from knowing you've done what's right. The judge exhaled slowly, rubbing his temples. Mr. Prosecutor, do you wish to redirect? No, Your Honor. Very well. He sat back, eyes scanning the file again, then the video timestamp logs, then Maya. Something in his expression had changed, not just embarrassment, but real discomfort. Like he was seeing a pattern he hadn't wanted to admit existed. Ms. Johnson, he said finally, you're citing case law most practicing attorneys wouldn't know off the top of their head. Where did you learn all this? I've been interning with the Southern Center for Human Rights since last summer, she said. We handle a lot of unlawful stop cases. I've read hundreds of rulings. I've sat in on depositions. I've helped draft motions. This isn't my first courtroom. The judge was silent for a long moment. Then, almost to himself, he muttered, I assumed. He stopped himself. But everyone heard it. The truth was he'd seen a black teenager in a hoodie and jumped to conclusions. He'd assumed she was lost, confused, maybe even defiant. He hadn't considered she might be brilliant, that she might belong here more than some of the lawyers who strolled in wearing $1,000 suits and barely knew their own case files. Now, the whole room was rethinking their assumptions too. The clerk, who'd barely looked up when she first entered, now watched her with quiet admiration. The woman in the front row, there for her own traffic ticket, whispered to her friend, She's just a kid. And she's schooling them all. Maya didn't notice. She was focused on the next step. Your Honor, she said, I moved to suppress all evidence obtained after the initial reason for the stop was resolved. Specifically, the questioning about my brother, the search of the glove compartment, and the citation for obstruction. None of it was legally justified. The prosecutor finally spoke up. Your Honor, we're not seeking jail time. It's a minor citation. Maybe we can just dismiss the obstruction charge and move on. Maya didn't flinch. With respect, that's not enough. If the stop was unlawful from the point the taillight issue was acknowledged, then everything after is fruit of the poisonous tree. Letting this slide sets a precedent that officers can detain anyone they feel uneasy about, especially young people of color, without consequence. Her words landed like stones in still water. Ripples moved through the room. Even the bailiff, who'd seen countless cases come and go, gave a slow nod. The judge looked down at his bench, fingers tapping lightly. You could almost hear the gears turning in his head, the weight of his position, the years of routine decisions, and now this moment, forcing him to confront something uncomfortable. Finally, he spoke. Motion to suppress, granted. A soft gasp came from the gallery. The citation for obstruction is dismissed, he continued. The taillight violation stands. But since the vehicle has since been repaired and the driver is a minor with no prior record, I'll waive the fine. Case closed, Maya stood. Thank you, Your Honor. But she didn't leave right away. She turned to the officer. I hope next time you'll remember that asking questions isn't defiance. It's a right. He didn't meet her eyes, just nodded stiffly. As she gathered her things, just a small notebook and a pen, no fancy briefcase, the judge called out, Ms. Johnson? She turned. Would you be willing to speak with our court's Judicial Education Committee about student practitioners? And courtroom conduct? It wasn't quite an apology, but it was close, and in that room it meant something. I'd be honored, Your Honor, she said. She walked out the same way she'd come in, hoodie, sneakers, head high. But now people watched her go with something new in their eyes. Respect? Yes, but also hope. Because if someone so young, so underestimated, could stand her ground with grace and knowledge, maybe the system wasn't as broken as it seemed. Maybe it just needed more voices like hers. Clear, calm, and unafraid to speak truth, even when no one expects you to know it. The moment she stepped out of the courtroom, the hallway felt different. Not quieter. There was still the usual shuffle of people, the echo of shoes on tile, the low hum of conversation. But something had shifted in the air, like the whole building had taken a breath and held it. People who'd passed her without a glance on the way in now slowed as she walked by. A woman holding a stack of legal papers gave her a small, knowing nod. A young man in a suit, probably a law clerk, actually stopped and said, That was incredible. She just smiled politely and kept walking, hoodie sleeves pulled over her hands, eyes focused ahead. She didn't want attention. She never had. All she'd wanted was to handle her brother's case without dragging their family into more stress. Their mom worked double shifts at the hospital. Their dad had been gone for years. Every dollar counted. Hiring a lawyer wasn't an option, so she'd become one. At least enough to stand in that room and speak for someone she loved. But news travels fast in courthouses. By the time she reached the lobby, a court reporter she'd never met before was already typing furiously into her phone. Someone had filmed part of the hearing on a grainy phone camera, just the moment the judge asked, Do you even know what an objection is? And her calm reply. That clip was already making rounds in local legal group chats. By lunchtime, it was on social media, not in a flashy, dramatic way, no music, no filters, just raw courtroom audio with a still photo of her standing at the defense table. The caption read, Judge mocks teen in hoodie. Then she cites case law like a pro. Within hours, it had thousands of shares. Comments poured in. She's 17 and knows more law than my attorney. This is why you never judge a book by its cover. That judge's face when he realized. She didn't see any of it at first. She was on a city bus, earbuds in, listening to a lecture on constitutional law while scribbling notes in the margins of her notebook. Her phone buzzed nonstop in her bag, but she ignored it. She had a study group at 3 p.m., then a shift tutoring high schoolers at the community center. Normal Tuesday. It wasn't until her little brother called, voice crackling with excitement, that she realized what was happening. Did you see it? He asked. You're all over TikTok. Even Ms. Rivera from school shared it. Shared what? She asked, frowning. The video. From court. You look so serious. And the judge, he totally ate his words. She sighed, rubbing her temple. I didn't go in there to go viral. I went in there to get your ticket dropped. I know, he said softly, but people needed to see it. You know? She didn't answer right away. She looked out the bus window at the passing streets, the laundromats, the corner stores, the kids playing basketball in the park. Places where people like her were rarely seen in court unless they were in trouble. Rarely believed, rarely given the benefit of the doubt. Maybe that was why this mattered more than she'd thought. Back at her apartment, a tiny one-bedroom she shared, with her mom and brother, her phone was lighting up like a Christmas tree. Messages from classmates, professors, even a few local news outlets asking for comment. One email stood out. It was from the director of the legal aid clinic where she volunteered. The subject line read, "We need to talk, urgently." She called him. "First off," he said, voice warm but serious, "everyone here is incredibly proud of you. But second, this is bigger than just your brother's case now." "What do you mean?" "People are talking. Not just online. The Bar Association reached out. So did a few civil rights groups. They want to know if you're willing to speak about what happened, not as a spectacle, but as part of a larger conversation about bias in the courtroom." She hesitated. "I don't want to make it about me." "It's not just about you," he said gently. "It's about every kid who walks into a courtroom looking like they don't belong and gets treated like they're wasting everyone's time. You showed what happens when you look past the surface." She thought about the judge's face, the way his voice changed, the way he couldn't meet her eyes after he realized who she really was. It wasn't malice, it was something quieter, more dangerous, assumption, the kind that builds walls without anyone noticing. A few days later, she agreed to a short interview with a local public radio station. No cameras, just her voice calm and clear explaining what happened, not with anger but with honesty. "I wasn't trying to prove anything," she said. "I just wanted fairness. And the law already says what's fair." I just reminded them. That interview got picked up by national outlets, not as a gotcha story, but as a quiet moment of reckoning. Legal blogs wrote about it. Law schools used the clip in ethics classes. Even the American Bar Association tweeted, "Competence wears many faces. Never assume." Meanwhile, the judge stayed silent at first. But pressure was building. Court staff whispered about the incident in hallways. Attorneys who'd appeared before him for years began asking questions. Had he done this before? To others? The Judicial Qualifications Commission, the body that oversees judges in the state, received 3 formal complaints citing conduct unbecoming and evidence of implicit bias. He could have ignored it.
Many would have.
But something about that day stuck with him. Maybe it was the way she'd spoken. Never defensive, never loud, just certain. Or maybe it was the realization that he'd nearly punished someone for daring to exist while black and young and brilliant. One morning, he walked into his chambers and asked his clerk to pull every case from the past year involving unrepresented black teenagers. He spent 2 days reviewing them. What he found unsettled him. Patterns, assumptions, shorter hearings, harsher tones, fewer second chances. He didn't like what he saw, so he did something rare. He requested a meeting with the court's Diversity and Inclusion Committee. And he asked if Maya would be willing to join the conversation. She agreed, but only if it wasn't a photo op. Only if it led to real change. They met in a small conference room, just the 2 of them and the committee chair. No press, no audience, just honest talk. He started by apologizing. "I assumed," he said, voice rough, "that because you looked young and dressed casually you didn't belong. That you were unprepared. I was wrong. And worse, I let my bias shape how I treated you in a space where everyone deserves equal dignity." She listened without interrupting. When he finished, she said, "Thank you for saying that. But the real test isn't whether you're sorry, it's what you do next." He nodded. "Tell me," she leaned forward. "Mandate implicit bias training for every judge, clerk, and bailiff in this courthouse. Not a 1-hour webinar. Real training, led by people who've lived this. And create a student practitioner liaison so young attorneys like me aren't mistaken for defendants just because we don't wear suits." He didn't argue. He took notes. A week later, he announced new courtroom protocols, mandatory quarterly bias training, a welcome guide for student attorneys, and a public statement, short, direct, and posted on the court's website. "I allowed unconscious bias to cloud my judgment. Ms. Johnson exemplifies the intellect, integrity, and dignity this profession demands, and I failed to see it because of how she looked. I am committed to doing better." The internet buzzed again, but this time the tone was different. Not mockery, but cautious hope. People shared the statement with comments like, "Accountability matters. Change starts here." She didn't celebrate. She went back to studying, back to tutoring, back to showing up for her brother, her community, and the next kid who walks into a courtroom wearing a hoodie and knowing their rights. Because the real victory wasn't the viral moment or the judge's apology. It was the quiet understanding spreading through the halls of justice that brilliance doesn't always wear a suit. Sometimes it wears a hoodie, and it deserves to be heard. Life didn't slow down after the courtroom moment went public. It sped up. But not in the flashy Hollywood way people might expect. There were no talk show invites, no book deals, no sudden fame that changed who she was. Instead, the days filled with the same rhythm they always had. Early mornings, textbooks, coffee that tasted like burnt paper, and long walks to campus with earbuds playing recorded lectures. Only now, sometimes, strangers would recognize her on the bus or in the library and give a quiet nod, like they were sharing a secret only a few understood. She kept her head down. Not out of shame, but because she knew the real work wasn't in headlines, it was in showing up, day after day, for people who didn't have a voice in places like courtrooms. Still, the ripple from that hearing kept spreading. A few weeks later, she got a call from her law school's dean. Not the usual check-in about grades or internships. This was different. The dean's voice was warm but serious. "We've been talking," he said, "about what happened, about what it showed us and what it could inspire." She listened, notebook open on her lap, pen hovering. "We want to create a scholarship," he continued, "for first-generation students of color entering law school. Students who face doubt not because of their ability, but because of how they look, where they're from, or what they wear. And we'd like to name it after you." She almost dropped the phone. I can't," she said quickly. "I didn't do anything special. I just used what I learned." "That's exactly why," he replied. "Because you showed that knowledge isn't about the suit you wear. It's about the mind behind it. And that's worth honoring." She didn't say yes right away. She thought about it for days. Talked to her mom, who wiped tears from her eyes and said, "Baby, if this helps even one other kid feel like they belong in that room, then say yes." So she did. The announcement came quietly, a press release from the law school, a small ceremony in the student lounge. No cameras, no speeches. Just a framed certificate and a promise. The Maya Johnson. Access to Justice Scholarship would cover full tuition for one student each year who demonstrated both academic excellence and a commitment to serving underrepresented communities. But the impact went further. Local. High schools started inviting her to speak, not as a celebrity, but as proof that a kid from their neighborhood, wearing the same clothes as their students, could walk into a courtroom and hold her ground. She didn't give motivational talks. She gave real ones. "You don't need permission to be smart," she told a group of wide-eyed teens at a Southside high school. "You just need to keep showing up even when people act like you don't belong." Teachers later wrote to her, saying students who'd never raised their hands before started asking questions in class. One boy told his counselor, "If she can do it in court, I can do it in calculus." Meanwhile, the judge, still carrying the weight of that day, followed through on his promise. He worked with the state bar to design a new training program for judges and court staff. It wasn't just slides and checklists. It included real stories from public defenders, from young attorneys who'd been mistaken for defendants, from community members who'd felt invisible in legal spaces. He even sat through the full 8-hour session himself, taking notes in the back row like a student. People noticed, not with fanfare but with quiet respect. Attorneys who used to roll their eyes at diversity initiatives now stayed after hearings to ask him about the training. One veteran public defender told him, "I've been in this system 30 years. I never thought I'd see a judge admit he was wrong and then actually do something about it." He didn't take credit. Whenever asked, he'd just say, "Someone reminded me what justice really looks like." Back on campus, she kept grinding. Finals came and went. She graduated near the top of her class, not with fanfare, but with the kind of quiet pride that comes from knowing you gave everything you had. At graduation, her mom sat in the front row, holding a tissue in one hand and her brother's hand in the other. No fancy dress, just her work scrubs under a borrowed blazer. But her smile lit up the whole auditorium. After the ceremony, a woman in a sharp navy suit approached her. She introduced herself as a senior partner at a civil rights law firm in the city, one known for taking on police misconduct cases, wrongful convictions, and systemic reform lawsuits. "We've been following your work," the woman said, "not just the courtroom moment. The tutoring, the clinic hours, the way you listen before you speak. We'd be honored if you'd join us." Again, she didn't jump. She asked questions about their cases, their values, whether they paid interns fairly, whether they let junior attorneys lead. The woman answered honestly, sometimes uncomfortably so. That's what convinced her. She took the offer. Her first case wasn't glamorous. It was a housing discrimination suit. Landlords refusing to rent to families using Section 8 vouchers, hiding behind credit concerns that didn't hold up under scrutiny. But it mattered, because behind every legal filing were real people. A single mom working nights, kids doing homework in shelters, elders forced to choose between rent and medicine. She threw herself into it. Drafted motions, interviewed witnesses, pored over rental records until 2 a.m. And when they won a settlement that forced the landlords to change their policies, she didn't post about it online. She just showed up at the community meeting to explain what it meant in plain language. No legalese, just clarity. People started calling her the hoodie lawyer, but not mockingly, affectionately, like it was a badge of honor. She never corrected them. Because the hoodie wasn't the point. It was what it represented, that you don't have to dress like power to wield it wisely. Months passed. Seasons changed. And then came the call she never expected. The Georgia Supreme Court was hearing a major case on racial profiling. During traffic stops, a direct extension of the very issue she'd faced that day in municipal court. Her firm was part of the legal team, and they wanted her to argue a portion of the oral arguments. She froze when she heard the news. Not because she wasn't ready. She'd prepped for weeks, rehearsed in front of mirrors, practiced with mentors until her voice didn't shake, but because it felt full circle. The same system that once doubted her was now inviting her to help shape its future. The morning of the hearing, she stood outside the courthouse, a grand, marble building that felt nothing like the cramped municipal room where it all began. She wore a simple black suit this time, not because she had to, but because it felt right for the moment. Still, she kept her hair natural, her posture relaxed. She wasn't trying to look like anyone else. Just herself, prepared, grounded, clear. Inside, the chamber was hushed, solemn. Just 7 justices, a few clerks, and the legal teams. No gallery, no cameras. Just the weight of the law. When it was her turn to speak, she stepped to the podium, took a breath, and began. She didn't shout. Didn't perform. She laid out the facts, cited precedent, connected the dots between policy and real human harm. And when one justice asked a tough question about officer discretion, she answered not with theory, but with truth. Discretion becomes discrimination, she said calmly, when it's applied unevenly based on race, age, or appearance. The law must protect everyone, not just those who look like they belong. Silence followed. Then a quiet thank you from the Chief Justice. Afterward, as she walked down the courthouse steps, she saw someone waiting near the fountain. It was the judge, the same one from that first courtroom. He wasn't in robes, just a button-down shirt, hands in his pockets, looking older, softer somehow. He didn't approach her right away. Just stood there watching her come down the steps. When she reached him, he gave a small respectful nod. "You did good," he said simply. She nodded back. "Thanks, no grand speech." No apology repeated. Just 2 people who'd been changed by the same moment, standing in the sunlight acknowledging what had passed between them. "I read your brief," he added. Clear, tight, powerful, she almost smiled. "You taught me something that day too." "What's that?" "That even people who make mistakes can choose to do better." He looked down, then back at her. "I'm trying. I know." They stood there for a moment longer, the city humming around them. Then he turned and walked away, shoulders a little straighter than before. She kept walking too, toward the bus stop, toward her next case, toward the next kid who might walk into a courtroom scared, underestimated, and ready to prove them all wrong, because the work wasn't done. But now more than ever it felt possible. Years passed, but the echo of that courtroom moment never faded. It just changed shape. It became a scholarship that helped a young woman from rural Georgia become the first lawyer in her family. It became a training program now required in courthouses across the state. It became a quiet understanding among judges that how someone dresses doesn't tell you what they know or what they're worth. She didn't chase fame. She chased fairness, and that kept her busy. Now in her late 20s, she ran her own small practice, not flashy, not downtown in a glass tower, but tucked into a converted storefront in a neighborhood that had long been overlooked. The waiting room had mismatched chairs, a coffee pot that always needed refilling, and a shelf full of law books next to children's coloring sheets. Because half her clients came with kids in tow, and she believed justice shouldn't require childcare you can't afford. Most of her cases never made headlines. A tenant fighting an illegal eviction, a teenager charged with trespassing for sitting on a public bench too long, an elderly man whose Social Security benefits were wrongly cut off. These weren't the kinds of cases that trended online, but they were the ones that kept people housed, fed, and dignified. And to her, that was the real work. Still, every now and then, the past would catch up with her in the gentlest ways. One rainy Tuesday, a high school student showed up at her office, clutching a folder and wearing a hoodie almost identical to the one she'd worn all those years ago. The kid was nervous, voice shaky, explaining that their little sister had been suspended for defiance after asking a teacher why a rule seemed unfair. "I saw your video," the student said, eyes wide. "The one from court. I thought, maybe you'd know what to do." She didn't sigh, didn't say she was too busy. She made tea, pulled up a chair, and listened. Then she helped draft a letter to the school board citing student rights under state education code. 2 weeks later, the suspension was overturned, and the district agreed to review its discipline policies. That night, she sat at her desk, rain tapping the window, and thought about how one moment, just a few minutes in a courtroom, had somehow opened doors for so many others. Not because she'd set out to be a symbol, but because she'd simply refused to be silenced. Meanwhile, the judge had retired. Not quietly, but not loudly either. He'd spent his last few years mentoring new judges, especially those from non-traditional backgrounds. He'd even co-taught a seminar at the law school on judicial ethics and bias, sometimes inviting her to guest lecture. They never talked about that day directly anymore. They didn't need to. It lived in the way he paused before speaking in court, in the extra care he took with young defendants, in the handwritten notes he'd occasionally slip under her office door after a tough case. "You reminded us what this robe is really for." Then came the invitation she hadn't expected. The Georgia State Bar was hosting its annual Justice Forum, a gathering of lawyers, judges, community leaders, and students to discuss the future of the legal system. They asked her to give the keynote. Not as a viral sensation, but as a practitioner who'd built a life at the intersection of law and humanity. She almost said no. She hated stages, spotlights, the feeling of being put on a pedestal. But then she thought about all the kids who'd emailed her over the years, kids who said her story made them believe they could belong in law school, in courtrooms, in rooms where power lived. So she said yes. The night of the event, the auditorium was packed, not just with lawyers in suits, but with community organizers, high school debate teams, public defenders with tired eyes and full hearts. She walked on stage in a simple dark dress, no notes, just her voice. "I'm not here to tell you I'm special," she began. "I'm here to tell you that none of us are. Not really. What matters isn't how smart you are or how well you dress or how many degrees you have. What matters is whether you show up. For the people who've been told they don't matter." She spoke about her brother, about her mom working nights, about the fear she'd felt walking into that courtroom all those years ago. Not of losing the case, but of being dismissed before she even spoke. And how that fear wasn't unique. It was shared by millions who walk into systems built without them in mind. "But here's the thing," she said, voice steady. "The law belongs to all of us. It's not a club for the polished. It's a tool for the people, and if it's not working for everyone, then it's not working at all." The room was silent when she finished. Then slowly people began to stand, not because she'd given a perfect speech, but because they recognized their own stories in hers. Afterward, dozens came up to thank her. One older woman, a retired teacher, held her hands and whispered, "My grandson wants to be a lawyer now. He says if you could do it, he can too." That was the real victory. Not the headlines, not the apologies, but the quiet chain reaction of hope. A few months later, she got a call from Emory Law. They were renaming the student legal clinic, the one where she'd first learned to draft motions and interview clients. From now on, it would be called the Johnson Community Justice Center. She cried that night, not out of pride but gratitude, because it meant the work would outlive her, that someone else would sit in that same room, nervous but determined, and know they belonged. Life kept moving. She took on a new intern, a bright, sharp-eyed college student who reminded her of herself. On their first day, the intern showed up in a hoodie looking unsure. "Don't worry," she said with a small smile. "You're exactly where you're supposed to be." And years after that, when she stood before the Georgia Supreme Court again, this time arguing a landmark case on equitable access to legal representation, she spotted a familiar face in the public gallery. The judge, older now, hair fully gray but posture still straight. He gave her the same small nod he had all those years ago. No words, just respect. After the hearing, they met outside on the courthouse steps just like before. "You've come a long way," he said. "So have you," she replied. He smiled faintly. "I read about the clinic, the scholarship, the kids you've helped. You didn't just change your life that day. You changed the room." She looked out at the street, the buses, the students, the people rushing to jobs and homes and dreams. "I just wanted to make sure the next person who walks in wearing a hoodie doesn't have to prove they belong." He was quiet for a moment. Then he said, "You did more than that. You reminded us all what justice looks like when it's human." They stood there in the afternoon sun, two people bound not by fame or titles, but by a shared moment that had cracked something open and let the light in. Back at her office later, she found a letter waiting on her desk. It was from a young girl in middle school, part of a program she'd spoken at. The handwriting was careful, the words simple. "I want to be a lawyer like you, not because you won in court, but because you were kind even when they weren't. I'm practicing my arguments in the mirror. My mom says I sound like you." She pinned the letter to the wall above her desk, right next to her law degree, because that was the legacy she wanted, not statues or headlines, but 1,000 quiet acts of courage, sparked by one person who dared to speak up while wearing a hoodie. And somewhere, in another courtroom, another young person was doing the same, standing tall, speaking clearly, and proving once again that brilliance doesn't announce itself with a suit. Sometimes it walks in quietly, hands in pockets, ready to change the world just by being seen. There was no grand finale to the story, because real life doesn't end with a bow. It keeps unfolding quietly in the spaces between big moments, and for her the work simply continued. Not for applause, not for legacy, but because someone had to do it, and she was still here, still able, still willing. Now in her early 30s, she'd stopped counting cases. Not out of indifference, but because each one carried its own weight, its own heartbeat. Some ended in victory, renters kept in their homes, wrongful charges dropped, families reunited after bureaucratic errors threatened to pull them apart. Others ended in compromise or even loss, but she never walked away from a client until every door had been knocked on, every appeal filed, every option exhausted. Her office had grown, not in size, but in spirit. 2 other attorneys now worked with her, both former interns who'd come in wide-eyed and left with a mission. They kept the same values. No client turned away for lack of funds, no question too small, no person treated as a file number. The coffee pot still leaked. The kids' coloring corner now had a tiny bookshelf. And the hoodie? It still hung on the back of her office door, worn, faded, but never forgotten. One spring morning, a letter arrived from the state's Judicial Education Board. It wasn't an invitation to speak or testify. It was something quieter, more profound. They were updating their training manual for new judges, and they wanted to include a case study, not about legal precedent, but about human perception. And they asked if they could use her courtroom moment as a teaching example. She read the request twice. Then she called the retired judge, the one who'd once mocked her, then apologized, then changed. "I got this," she said, reading him the letter over the phone. There was a long pause. Then he said, "It's about time they taught this not as an exception, but as a lesson." They worked on the case study together. She from the perspective of the advocate, he from the bench. They didn't sugarcoat it. They wrote honestly about assumption, about shame, about the slow hard work of unlearning bias. They included the body cam timestamps, the legal citations, but also the emotional truth. How it feels to be seen as a problem before you're seen as a person. When it was published, it became required reading for every new judicial appointee in the state. That same week, something unexpected happened. A high school in a neighboring county reached out. Their mock trial team had chosen to reenact her case. Not the viral clip, but the full hearing with research, arguments, and even a recreated courtroom. They asked if she'd come watch. She almost said no. She was swamped with a housing rights class action suit. But then she remembered being that age, believing the law was only for people who looked a certain way, talked a certain way, came from a certain place. So she went. The students were nervous. Some stumbled over objections. One forgot their line and froze. But they tried, and in the role of the young defendant, a quiet girl with braids and a second-hand blazer delivered the legal arguments with such focus, such care that the room fell still. Afterward, the girl approached her, eyes shining. "I was so scared to play you," she admitted. "Because you're you." She knelt slightly to meet her at eye level. "I was scared too," she said. "But fear doesn't mean you stop. It just means you care." The girl nodded, clutching her script like a shield. "Do you think I could really do this?" "For real? Already are," she replied. "You just argued constitutional law in front of 30 people. That's real." Later, as she drove home, she thought about how change doesn't roar, it whispers. In classrooms, in training manuals, in the way a teenager stands a little taller after seeing someone who looks like them hold their ground. Back at the office, her team was waiting with news. The class action housing case, the one she'd been buried in, had settled. Not perfectly, but fairly. The landlord agreed to fix unsafe conditions in over 200 units and stop retaliating against tenants who reported issues. It wasn't a headline-grabbing win, but it meant children wouldn't sleep next to moldy walls. Elders wouldn't choose between heat and medicine. Families could breathe. That night, she didn't celebrate with champagne. She ordered takeout, sat on the floor of her office with her team, and let herself feel the quiet relief of a job done right. A few days later, she got a call from the law school. A new student had enrolled in the scholarship program, first in her family to go to college, working nights at a grocery store, commuting 2 hours each way. She'd written in her application, "I saw what the Johnson Scholarship made possible. I want to be that possibility for someone else." They asked if she'd meet her. She did. Over coffee, the student talked fast, hands gesturing, eyes full of that mix of hope and fear she remembered so well. "I keep thinking I don't belong," the student confessed. "Like they'll find out I'm not smart enough." She leaned forward. "You know what belonging really is? It's showing up even when you're scared. It's asking the question no one else will ask. It's staying when it gets hard. You're already doing it." The student smiled just a little. "I brought my hoodie," she said almost shyly. For good luck, they both laughed. And in that laugh was a thread, connecting past, present, and future. Time moved on. Seasons turned. The world kept throwing challenges, new laws, old injustices wearing new masks. But the work adapted. Her practice started offering Know Your Rights workshops in community centers. They partnered with schools to teach teens how to interact with law enforcement safely and assertively. They even launched a hotline for people facing eviction, staffed by volunteers and law students. None of it was glamorous, but all of it mattered. Then, one ordinary Tuesday, she received an email from the state bar. They were creating a new award, the Community Justice Champion, and they wanted to honor her at their annual gala. She almost declined. Awards felt like endpoints, and she wasn't done. But her team convinced her. "It's not about you," one of them said. "It's about showing others that this path is valid, that serving your community is excellence." So she went. She wore a simple dress, no jewelry, hair in its natural curl. When they called her name, the room rose, not in polite applause, but in something deeper. Recognition, gratitude. In her short acceptance speech, she didn't talk about herself. She talked about the single mom who fought her landlord and won, the teenager who graduated law school on the scholarship, the retired judge who spent his last years teaching others to see clearly. "Justice isn't a solo act," she said. "It's a chain, and every link matters." After the event, as she walked to her car, a young attorney stopped her. "I clerked for Judge Whitmore my first year," they said. "He made us watch that courtroom video every month. Said it was the most important lesson he ever learned." She smiled. "He taught me something too." "What's that?" "That it's never too late to change." She drove home under a sky full of stars, windows down, city lights blurring past. No fanfare, no cameras. Just her, the road, and the quiet hum of a life spent building something that lasts. Because the truth was, the story wasn't hers alone anymore. It belonged to every person who'd been doubted and showed up anyway. To every judge who paused before speaking. to every kid practicing arguments in the mirror. And as long as there were rooms where people were judged by their clothes instead of their character, the work would continue not with a bang but with 1,000 small acts of courage, kindness and unwavering belief that everyone, no matter what they wear, deserves to be heard.